my lord, to mention, my lord, a PLA matter, my lord, with absolutely innocuous praise, my lord. But what had happened is, my lord, in the cost style, my lord, we generally write, my lord, lately residing at. Now, my lord, the death certificate, my lord, has two addresses. Lately residing is correct, my lord, absolutely correct. But since it has two addresses, my lord, the department is of the view, my lord, that the second address should also be inserted, my lord. For which, my lord, I have to seek leave from this court, my lord. Non-contentious, my lord, all, my lord, the legal heirs have given their affidavits of consent, my lord. So, it could be fixed under to be mentioned, my lord, and my lord, also could be
Okay.
possible.
To be mentioned tomorrow.
Obliged, deeply obliged, deeply obliged.
My lord's kind is to mention a non-contentious probate application for inclusion, my lord.
Original side matter, 1030 fixed matter for orders, item number 1. Excuse me, please. Excuse me.
From the above, it reveals that the present applicant, Mr. Banerjee, was allowed to be impleaded as a party defendant in the said suit, and he was also permitted to file the written statement therein within a period of 1 month from the date. The department was also directed to carry out necessary amendment in the plaint accordingly. If that be so, it is not correct to say that he was not added a party defendant in the said suit, and that was why he could not contest. This plea cannot be accepted since by order dated 11th May 2004, the court itself impleaded him as a party dependent and department was directed to carry out necessary amendment in the plaint. Therefore, the question of impleadment from the side of the plaintiffs, the decree holders, does not arise. More so, Mr. Banerjee was also permitted to file the written statement in this suit within a period of 1 month from the date. It goes to show that all necessary actions for impleadment of the present applicant were complete, and the same was not dependent upon the plaintiff's action as alleged by the present applicant throughout these proceedings as well as in other proceedings also. Therefore, when the present applicant was already added as a party to the proceeding and he refused to submit written statement within the time stipulated by the Honorable Court, can he again take the plea that as the plaintiff did not amend the plaint or as the plaintiff did not take any steps to implead him as a party, he could not contest? In view of the materials on record, the applicant cannot be designated as a stranger or a third party to the proceeding. He was given opportunity to contest the suit and all necessary actions regarding his impleadment were completed, but in spite of that, he did not file the written statement for reasons best known to him. The attitude of the applicant, Mr. Banerjee, is not at all bona fide. It appears from the above that in spite of direction, he did not take any step to file written statement in the relevant proceedings. However, it further shows that soon after passing of the ex parte decree, he filed an application before the concerned court for setting aside such ex parte decree under Order 9, Rule 13 of the Civil Procedure Code, but the same was refused. Thereafter, he preferred an appeal, which was also dismissed. This unveils another aspect of the present applicant, which shows that without taking part in the relevant suit proceeding, in spite of having opportunity to do so, he kept a close vigil over the ongoing proceedings and took appropriate steps as and when required. This sort of attitude cannot be accepted, and he shall not be allowed to abuse the process of court. It appears that he was given sufficient liberty to take his plea defense before the concerned court, but he did not avail the opportunity. Rather, he played hide and seek, which cannot be permissible in the legal realm. Considering all aspects of the matter, I find that the intervener does not come with clean hands, and as such, I am not inclined to allow his prayer for intervention. Accordingly, the GA number 1 of 2024 is dismissed with a cost of rupees 10,000. In view of the above, the learned receiver is directed to hand over physical possession of the suit premises to the decree holders in accordance with law after complying with all legal formalities, and to submit a report within 10 days from the date. In case of resistance, he is allowed to seek police assistance, and the jurisdictional police station shall extend all sorts of cooperation to implement the order of the court. That's all.
Grateful, man.
Next. না এটা তো জিএটা ডিসপোজড অফ হলো না আফটার 10 days. ডেট দিয়ে দাও রিপোর্ট ফ্রম দি রিসিভার।
হ্যাঁ।
নেক্সট।
হ্যাঁ, চেঞ্জ করো। Original side commercial division, item number 1.
And I'm for the judgment debtor, my lord.
And I'm for the decree holder, my lord.
May I file my affidavit?
You file
This was due to be filed long
is
back,
this?
my lord.
It's the affidavit of assets, my lord.
affidavit of assets,
Assets,
judgment
my lord.
debtor.
There was an order directing me to file my affidavit of assets.
Copy.
My lord, nothing has been served.
Copy,
Copy, sir.
I'm giving here.
And I don't know why, when it was affirmed,
I'm giving here and now.
now, here and now doesn't matter, my lord. You will see the order of Justice Kapoor, my lord. When it was directed and what he is filing today. And he doesn't have the courtesy of sending a copy in advance to the advocate for the decree holder. It was affirmed in July 2023, and today he's handing it over to me.
There was a settlement in the.
No, my lord, settlement doesn't matter, that the order has to be complied with.
Order, it has been affirmed.
He is paying part amount, my lord. He is contesting suit here. There are two decree, my lord. Your lordship will see. There was a decree on judgment on admission, my lord. There was a decree for further, there was a second decree for payment of interest, my lord. There's a proceeding of 138, my lord, going on in Metropolitan Magistrate. There, my learned friend, client is also contesting. Even that matter is fixed today.
138 matter, I will not contest.
No. His client is, Mr. Das is my counsel. You also can,
May I indicate, my lord, there was a decree passed in March 2021. From the time when this decree was, my lord, the decree was in respect of certain goods sold and delivered, in respect of which I had instituted a suit. There was admission on their part, and decree was passed in respect of the admission amount. The amount along with the was 9 lakhs, along with the interest was approximately 12 lakhs. My lord, thereafter they filed an appeal. My lord, the appeal was, they did not even pay the court fees for the appeal. The appeal was lying in the list and thereafter dismissed.
Court fees has been
My lord,
paid. I do not.
It was
know.
dismissed.
No, it was.
Thereafter, they filed restoration.
The ground of court
They
fees.
had filed restoration, and then thereafter the appeal was dismissed on merits. My lord, they have been, this application, the EC has been filed in 2022. From that date, there were several directions for disclosure and affidavit of assets. They have time and again either been absent at the hearing or sought adjournment. And my lord, till date, even affidavit of assets has not been filed.
No, it has been filed.
Today it has been filed. A copy affirmed in July 2023, my lord. My lord, the conduct of the the decree,
There
holder,
are
the judgment
the
debtor
was not
is
called out.
extremely
That is why he has
notorious,
not
my
been
lord.
paid.
I am only seeking the injunction orders are already in place, but I believe there is nothing in those bank accounts, which is why they are running away. My lord,
So you
No,
want
no,
to,
today to
you
show
want
my.
to examine the,
Yes, yes,
my lord,
they are.
either my lord, my first prayer would be to renew the filing of the affidavit of assets. Although
that
their
is
right
there.
has been closed, today they have filed. My lord,
Now,
now, my lord, this disclosure I will inquire, and my lord may direct the judgment debtor to be present. We shall examine them.
take for examination.
Examination.
only one thing, your lordship proceeds on the prayer of a learned friend to order examination. Your lordship will kindly see the language of order 21, rule 41, why it is required. If I can show that I have other debts recoverable, then also that procedure has to be adopted first. The garnishes has to be issued a notice, because the language is that to find out whether there is any debt owed to the judgment debtor. Debtors owes debt to me. So that's why this provision I have made this application under
What is
order
the provision?
21 rule 46.
Order
Kindly see
20
order 21 rule 41 first. Kindly see the language, whether at all it is required or not. If it is found that my debts owed are not enough to satisfy that debts, obviously I will be
Order 21.
rule 41. Lordship will see.
Yes.
May I read? Where a decree is for payment of money, a decree holder may apply to the court for an order that the judgment debtor or where the judgment is a corporation, any officer thereof, any person be orally examined as to what is the purpose, as to whether any or what debts are owing to the judgment debtor, and whether the judgment debtor has any and what other property means for satisfying the decree. The court may, is it discretion left upon the court? Court may an order for the purpose of attendance and examination of the judgment debtor. So the first and foremost condition which he has to satisfy, what is the purpose, is that to find out whether any debts is owed to the judgment debtor or not. Now your lordship will kindly take order 21 rule 46.
Yes.
Attachment of debt, share and other property not in possession of judgment debtor. In case of any debt not secured by negotiable instrument, a share in the capital corporation or other movable property not in possession of the judgment debtor, except property deposited in the custody of the court. Now, lordship will straight away come to sub-rule 3. A debtor prohibited under clause 1 of sub-rule 1 may pay the amount of his debt into court, and such payment shall discharge him as effectually as payment to the party entitled to receive the same. Notice to a garnishee. 46 says the court may, in the case of a debt which has been attached under 46 upon application of the attaching creditor, that is, or upon my application, issue a notice upon the garnishee liable to pay such debt, calling upon him either to pay into the court the debt due from him to the judgment debtor, or such may thereof as may be sufficient to satisfy the decree and cost of execution, or to appear and show cause as to why he should not do so. An application to that effect shall be made by an affidavit verifying the facts and stating in belief to the deponent the garnishee is indebted to the judgment debtor. Where the garnishee pays the amount in court due from him to the judgment debtor, or so much thereof is sufficient to satisfy the decree and the cost of execution, the court may direct the amount may be paid to the decree holder towards the satisfaction of the decree, the execution. So, lordship, the provision of law gives me a remedy that if certain debts are owed to me by a debtor who is the garnishee, I am the creditor to the debtor, those your lordship can direct them. The debts can be attached and direct them to appear in court and show cause as to why he should not. Otherwise, if he cannot, then the debts will be directly paid to the decree.
What the garnish is here?
Yes, your lordship, I made an application to that effect.
When?
It is appearing in the list. GA1.
No copy has been served on us.
They will serve a copy. They will serve a copy. In whatever debts we have disclosed in the affidavit of assets, same.
You have to have the copy.
We will serve. Your
And
lordship.
my lord will
It is a
kindly,
requirement of law.
Yes, your lordship, we will serve. Without service, you are not.
my lord, I may
Then
indicate,
you are getting the time. You are getting the time.
No, your lordship,
Killing-
will kindly.
client is killing the time.
Your lordship, that's a mistake on my advocate and record. I tender my apology.
my lord, we were here yesterday. They indicated and we requested
No,
copy.
I tell you, your lordship.
Mistake of advocate. This is a sacrosanct.
No, I'm not saying sacrosanct.
No,
because
I am saying.
settlement was going on before the bank shall go.
I am saying.
We have already paid 2,50,000. That's why this application has not been
Okay,
served because
when
settlement was
you
going on.
serve the copy?
We
Today.
will- Here and now.
Here and now. Come back tomorrow.
And my lord, may I indicate one thing before my lord, because the affidavit has been brought in today. May I indicate one thing?
You go through the affidavit first, then come back.
Indeed.
Your lordship,
No, my lord,
Your
only one issue, my lord.
One
My lord, there is a debt on the basis of which a decree has been finalized. Now he is sending me after his creditors who may come and say, I have no debt.
Provision of law
He
provides
has
that.
indicated certain amount. He has indicated certain amount that creditor, I again have to wait
You don't
till
have to
the
go-
time
go
the
to the
amount has
particular.
been proved. Instead, my lord, he has a property which is situated at Gold Park housing. Let that property, at least there be an injunction in
Yes,
respect
yes,
of
let
that
there be
particular
injunction. We have
property.
notified.
Let it, my lord, he has, this is paragraph 8 of his affidavit of assets.
So you
This
are
was-
ready with his affidavit of assets right now?
No, I am not ready, my lord. In that case, my lord, I'll come back. I'll come back. I don't.
They are concerned with the satisfaction of the decretal dues. If they get
Absolutely.
it from my debtors and the law provides that remedy, then why not?
Yes.
This right should be exercised.
Yes, yes, why not? I
don't
am,
have the means.
always here with you to satisfy the decree
Very well, my lord.
supported by you.
Yes,
What-
I
whatever
am
it
not
may be.
able to. That's why lost in appeal.
Whatever it
I
may
am
be.
saying that I don't have the means right now to pay the decree, but I have a certain money which is owed to me by the debtors. Your lordship, the purpose, your lordship, the language
That
has
is
seen.
admitted by the other side. That
Your lordship,
garnish.
this date has to be attached and notice has to be issued.
Okay.
Your lordship, if the law provides that, then
So,
this provision would not have
By
been there.
the execution proceeding of you of your other side, you are now executing your death.
No, your lordship not executing. Then this remedy would not have been provided in this.
Okay, I shall consider. I am not shutting
Your
the
lordship
door of
can
the court.
throw away my application just like
I have
that.
to hear their.
And the remedy is provided under the CCP.
I have to hear their version also.
Yes, your lordship will hear.
So
But the fact is that
why
whether they get the money from me or my debtors, your lordship,
why
they are
the-
concerned
why
with
the examination is not necessary?
the examination is not necessary because your lordship, the purpose of the examination is to find out whether any debts is owed to the judgment debtor. or
Examination
any
means
property.
cross-examination. Yes.
Yes,
Yes.
yes, he will cross-examine my witness
Yes.
to find out whether there is any asset in my possession which will satisfy the decretal.
Whether this affidavit of assets has any importance unless that has been cross-examined by other side.
I am saying that the
No.
cross-examination
Please
stage will
tell
arise.
me. Please tell me. You have submitted one affidavit. Unless it is
Application I
tested, unless it is tested by cross-examination of other side.
will be tested provided it is required to be tested. Why
That-
I say so?
No. Whether there is any requirement or not, that will be decided by me. Okay.
If to be satisfied that the requirement is not there, now your, it
Okay.
is your lordship discretion.
Okay,
whether
you
lordship
please
will
come
allow.
back with proper instruction tomorrow. Okay. And you have supplied all the copies. The previous GA or something
That's
like that.
No, this is not. This is the old application.
No.
This is the yes,
The learned counsel for the judgment debtor has submitted affidavit of assets of the judgment debtor. Stop. Copy served. Stop. Yes.
আর ওর মধ্যে আছে দেখ
The learned counsel of the
Yes,
judgment
দেখা-
debtor has
দেখা
also
যাচ্ছে।
served copy of which GA?
লর্ডশিপ the application GA number 1
GA number 1 of
2023
2023 to the learned counsel of the decree holder.
মাস্টার সামনে
Stop.
তারপরে আছে।
Para. The learned counsel for the decree holder has sought for an
মাস্টার
accommodation
সামনে তারপরে আছে।
for coming back with proper instruction. Please the matter tomorrow. কত তারিখ?
7th March.
7 March. Okay.
So as a counsel, it's my duty to
Yes.
press my case before your lordship. I will satisfy whether, if at all, but kindly don't take me amiss. Obviously, your court will decide.
And please,
But it is my
please,
duty to
as a
press my
judge,
best case before.
as a judge, I have duty to hear both the sides.
Correct. I am grateful.
Am I correct?
Yes, absolutely. The lordship is always correct.
Okay.
Lordship, may I only request for one thing? Instead of 7, can we 8? Because my lord junior
I
has
have no.
certificate.
I have
8 March করে দিন তো।
8th March.
Great.
Okay.
Extremely great.
Item number 2.
I am for the judgment data number 3.
My lord, I am appearing on behalf of the decree holder and I am seeking for a day's accommodation on the ground that the
I can't get you.
I am seeking for a day's accommodation on the grounds that the learned counsel arguing the matter is not in town.
Okay. Not this week করে দাও তো। Each and every day.
My lord, the marshal
What can
concluded
I
the
do?
agreement on
11th.
long back.
If I can make a humble prayer, my lord, whenever this matter is taken up, irrespective of if the parties are appearing or not, I would prefer to file a small note. But
Yes, yes.
ultimately, there are certain
Not
facts
this
which
week করে দাও এটা। হ্যাঁ, ঠিক আছে।
11th March.
a leave could be given, my lord. I'll file
Okay,
a small.
not now, right now.
11th March. Original side matter to be mentioned item number 2.
Wait, please, your lordship. My lord, this is appearing at my instance, my lord. I had mentioned this matter yesterday. My lord, in a probate proceeding, my lord, I am for the, my lord, the executor, my lord. Executor has been examined. It is pending for cross-examination, my lord. In the meantime, what has happened is, my lord was suffering from dialysis. Now there's been kidney transplant. And he resides in Mumbai, my lord. That is the difficulty, my lord. I was humbly praying, my lord, he is in Kolkata. And my lord, this is the last order which was passed by Honorable Justice Krishna Rao, my lord. This was supposed to be fixed on 5th, my lord. Well, however, now since the determination is before lordship, my lord, I was humbly praying if your lordship will kindly fix a date and time, my lord, subject to your lordship's convenience, because he comes from Mumbai, my lord, and because of his medical condition, the cross-examination may be done by my learned friend.
Lord, I appear for the defendant. I shall be cross-examining him. Lord, I have no difficulty. Whatever date commends to your lordship, Lord, we'll be there.
My lord, may it be kept tomorrow, my lord. He is there in Kolkata.
No, my lord, tomorrow I'm not. My lord, this week is. I am actually not in Kolkata, my lord. I'm in Delhi. Could it be any day next week, my lord, subject to your lordship's convenience?
Any day, my lord.
Monday, then.
Very well, my lord. Very well.
The learned counsel for the.
My lord, can it be on Tuesday, my lord, then?
Yes, Tuesday.
No difficulty, my lord. No difficulty.
Counsel for the executor has submitted that as the cross-examination of the executor is going on and
commencement
as the state executor is now staying at Kolkata for medical purposes, a date may be fixed for his further cross-examination upon notice to the other side. Stop. Para. The learned counsel for the judgment debtor is present virtually. Stop. Para. List the matter. কত হবে মঙ্গলবার কত তারিখ হচ্ছে গো আরো 12 list the matter 12th March at 12 noon কিছু আছে 12:15 কিছু আছে at 12:15
for the defendant, my lord.
নেই তো what happened
Instead of judgment data, my lord, defendant, we have to defend.
oh sorry
Instead,
from execution case to
that is
testamentary suit.
that
Okay.
is why we discussed.
Okay. Yes, learned counsel for the defendant, not judgment debtor. At 12:15.
Grateful, my lord. Obliged.
12:15,
my lord.
12 March. Okay.
Grateful, my lord.
এটা আগে কোনো ডেট ছিল না তো 5th March ছিল আগে কত
Grateful.
Item number 3.
Please, your lordship. My lord, this is a contentious testamentary suit.
You are appearing from whom?
I am on behalf of the defendant. I filed the caveat. This is a contentious suit. The examination was relegated to a commission.
Examination of which witness? Examination of whom? Examination of whom?
My Lord Justice,
Examination.
Honorable Justice Krishna Rao, my Lord.
Who is being examined? Who is the
Examined
witness?
now the plaintiff himself, the executor, is being examined. He was supposed to be examined. Now what's happened? He's saying, no, I will not be examined. Let the other witnesses be examined. I will retire hurt and come on to bat later on. Now that is not permissible. Under Order 18, Rule 13A.
Is there any petition?
No, nothing.
Then
Yes,
how can it be accepted?
There is an order of Justice Rao, but then he's taking advantage of the order now and he's indulging in this act. Now, once his examination has started, he has to complete the examination. Otherwise, if he brings in the other witness, attending witness, he will try to cover up the lacuna. That cannot be done under Order 18, Rule 3. I brought 3 judgments.
Whatever it may be, without petition, can it be done? I think
Yes, yes.
My lord, may I
Because
submit?
this order,
he has to file an application. If he
this order
where
was,
is the order?
this order was
Please.
passed without any application on mentioning.
Please mention.
My lord, may I submit one thing? Mr. Amitabh Mukherjee is appearing in this matter, and he is due to personal inconvenience, he is not
Commission
come
is
before
to
the
be
court
held on
today.
Saturday.
And the advocate on record is also out of the town
He
today.
was here yesterday. I served
So I
him.
am praying for a not today,
Commission
sir.
is on Saturday, please.
Kindly give me one day accommodation.
Was
Kindly
passed
give me
without
one day
any
accommodation.
application. On to be mentioned, this was passed, and now they're trying to take advantage of this. How can this be done?
Kindly give me, my lord, one day accommodation.
Without notice, you have moved.
Yes, my lord.
Without notice, this application was moved.
Actually,
my lord, I have been appointed by my lord.
Have you received your remuneration?
My lord, no, first sitting, no. The said other
No,
proceedings
no,
I have.
Oh, without payment, you cannot. We should not go.
No, my lord, I have already conducted. My lord, I couldn't say anything. My lord.
Please read this order, 25th January 2024. Please.
my lord, actually, I am not briefed in this matter. It's my colleague's matter, so I am not aware about this matter. I'm
Don't worry.
just.
I shall consider your plea.
For my lord, the plaintiff says, my lord, that
What is the order? I want to know first, please.
Yes. Counsel for the plaintiff.
25th January.
Yes, yes.
Yes.
Counsel for the plaintiff submitted the examination of the plaintiff witness number 9 is going on, but due to ill health of the plaintiff's witness, the plaintiff's witness is not in a position to appear before the commission for further examination, and he prays for further extension. Counsel for the plaintiff further submits that the witness of the plaintiff will be available in the month of February 2024. Considering the submissions made by the counsel for the plaintiff, this court finds that as the witness of the plaintiff is not coming forward for further examination, the commissioner is not in a position to continue with the examination of witness. In view of the above, this court permits the commissioner to examine the other witness of the plaintiff by deferring the examination of the plaintiff witness number 1, when the plaintiff's witness number 1 will be available to appear before the commissioner, his examination can be resumed. Now he is there. He is not ill anymore. He is not coming forward.
But counsel for the defendant is there. You are present.
Counsel, I was there, but now what?
Now tell me, you are there. I am under the impression that you are not there. You have moved. He has moved the application without notice. Now tell me the next line.
Yes. Counsel, he will adduce one witness. No, that is, I will adduce the witness after his case is over. In view of the above, time to complete the examination of witness and to file a report. Now, what's
But you did not raise any objection to that.
The question we raise an objection. The question is now.
You file an application.
He is taking.
Please, you file an application for recalling this order. If you do, if you can do so, I can consider your prayer. Okay. For the time being, you should not go examine the. Okay. When you will file?
Next week. By next week, I will file the
learned counsel for the defendant, no? Defendant has submitted that he will take steps for recalling the order dated 25th January 2024. Stop. The learned counsel for the plaintiff, no? Learned counsel for the plaintiff. Learned counsel for the learned senior counsel for the plaintiff is not available. Stop. Please the matter. Tuesday?
Not no, because once it's filed, it will take 2 days to come up, and
okay.
There is
after 7 days going to the learned commissioner is present. Stop. The order no. He's directed not to proceed with the process of examination until further order. Okay. You should be always present here whenever it. Something for
remuneration.
13th March. Okay.
Remuneration patient. My lord, his remuneration should be paid by the plaintiff.
Okay, senior counsel, let the senior counsel come. Okay, I am always here. Don't worry. এই আমার এটা কোথায় গেল? এই যে এখানে, ঠিক আছে, দেখো। Under the heading to be mentioned.
Item number 4.
My lord, item 4 is, my lord, a non-contentious probate application, wherein, my lord, by an order dated 22nd September 2023, my lord, probate was granted. Now it is ready, my lord, to be handed over the certificate. At the time of scrutiny, my lord, it was found that in the cause title, my lord, the pin code of Kolkata should be Kolkata 7,64,000, wherein, my lord, typographically, by typographical mistake, it was written as Kolkata 91. So, my lord, that correction, my lord, in all the cause title, my lord, has to be made. So, my lord, only a correct order for, my lord, formal correction order be given. My lord, Salt Lake City, BF 174 in the cause title, if your lordship finds out, Sector 1, Salt Lake, Bidhannagar East, Kolkata 91, it should be 64 instead of 91. All formalities are complete, your
Counsel
lordship.
for the petitioner has submitted that due to oversight, a mistake occurred in the relevant pin code of the whose address it was?
My lord, it was the address of the deceased, your lordship.
Address of the pin code
Deceased.
of the deceased address. As such, he prays for a formal order of amendment. So I am giving you leave to amend
Your lordship can
department.
correct it by passing an order here and now, my lord.
Sure.
Because all formalities are complete, only the cost title, that 91 should be changed at 64.
The cost title showing the pin code. Please tell me the pin code already in the
My lord, pin code is 7,91,000. It should be 7,64,000.
পিন কোড যেটা বললো 91টা 7,91,000 be corrected, and in place of the same the pin code being 7,64,000 be inserted in the cost title. Cost title of the
My lord, all the cost titles, kindly, my lord.
In all the cost titles?
All the cost titles of the petition, my lord. Because there is an affidavit of asset, there is
of the
attesting witness, all the cost titles.
petitions. But is a Herculean stuff.
No, my lord, only that typographical error, it could be cut down by the pen, my lord, strike off by the pen. Formal order from your lordship is required.
The department in all the cost titles. All the cost titles. The department is to carry out. ঠিক আছে। Okay.
Deeply obliged, your lordship.
Order correct. 22/9/2003. Item number 5.
My lord, item number 5, may it please, my lord. My lord, this is appearing at my instance. It is a probate application of the year 2020. May I just briefly indicate the facts, my lord? The deceased testator was in a live-in relationship with a certain individual named Rai Mitro. Out of the said live-in relationship, the executrix of the present petition, the petitioner, was born. Upon in the lifetime of the testator, he executed a will, and in the will, the petitioner herein has been made the sole beneficiary as well as the sole executrix. Now, she has filed this probate application for grant of probate. Now, because of this twisted relationship dynamics, she's not aware of who the legal heirs were because she was never in touch with the actual family of her father. But it so transpires that her father was legally married to one Mita Chaudhuri. That is the only knowledge she has of the legal heirs. And she somehow managed to obtain an address. Based on that, the probate application was filed. Last year in June, 21st of June, Honorable Justice Krishna Rao was pleased to pass an order to issue citations. My lord, general citations, special citations were issued, and paper publication was also complete. Subsequent thereto, no caveat has been lodged as yet. Now, what has happened after that, my lord? The special citation has been returned to the department on the ground that the address is insufficient. So, my lord, I requested my client to find out the actual address. Although she tried her best, she found an address, the complete address, just a few blocks, and the floor was missing. We found the complete address. We took out a GA application, amendment application. We amended the address of the legal heir, the only known legal heir. And on November 2023, Honorable Justice Krishna Rao was pleased to allow the amendment, and it has been amended in the petition as well. So right now, my prayer before your lordship is a special citation, a direction may be issued so that a special citation may be issued afresh on the legal heir based on the amendment that I have carried out, just to maintain my bona fide.
Very good. The learned counsel for the petitioner has prayed for issuance of special citation after the citation in respect of the available address of the
Legal heir.
legal heir
Legal heir.
of the
The-
deceased.
Yes.
Stop. The learned counsel has further submitted that necessary amendment in the relevant record has already been carried out. Stop. Para. Let there be an order allowing the prayer for special citation as whether you have filed any application.
Lordship, the prayer is appearing in my main application. I have amended the main
What is the
application.
prayer?
Lordship.
D-
Yes, Lordship.
Let there be an order of
Kindly comes to page 7, Lordship.
is-
That is
what is the
AA. Should be AA. Prayer AA. PLA.
A? Only A.
No, double A, because it was
Double A.
amended.
Let there be an order. Let there be an order in terms of prayer AA of the
probate application.
Probate application. Stop. List the matter after 4 weeks.
I'm deeply obliged, my lord. Deeply obliged.
For hearing. For hearing on 4 weeks মানে হচ্ছে আজকে কত তারিখ 5 তো এই 3rd April item number 6.
I am for the petitioner.
I beg to appear for the caveatrix, the only daughter of the testator.
They have filed an affidavit in support of the caveat. That was treated as the written statement. PLA petition was treated as a contentious cause, and testamentary suit number was granted.
Yes.
Remaining discovery inspection order was required for discovery inspection and the file judge's brief of document and fixing a date for filing suggested issue by both the parties. Your lordship issue the
admission and denial. Affidavit of admission and denial.
Sorry, I beg your apology.
Then
that was
You
also
always
sorry,
submit in this fashion.
May I have an innocuous prayer? Item number 6 and 7. Two wills were executed allegedly by my father, and I am the caveatrix in both of them. And one of the will was with regard to one medicine shop owner, another was with regard to a nephew. Both may both be treated as my lord analogous hearing.
Yes, it is going on. Analogous. Both. Do you have any objection?
No.
একই common order করবে না? The learned counsel for the parties are present. Stop. It appears that the daughter of the testatrix or testator has lodged caveat, and also in support of such caveat, affidavit was also filed. Stop. Let the said affidavit be treated as written.
That what is already passed by my
Already
Justice
passed.
Rao.
Okay. Then we keep it. Stop. Stop. and the instant matter has been marked as contentious. Okay? Contentious. Stop. The parties are directed to go through the process of discovery and inspection within 15 days from the date, and affidavit containing admission and denial, if any, be furnished within 7 days thereafter.
My lord.
Stop. List the matter for framing of issues after 4 weeks.
I'm grateful, my lord.
একটা ডেট দিয়ে দিন তো। এটা না 6 and 7 দুটোতেই হবে।
হ্যাঁ 6 and 7
Honor.
Let there be an order recording.
Yes. As per prayer of the learned councils of the parties,
আর এপ্রিল
both the matters being such and such, being TS 4 2023 and TS 16
আসবে
2023
তিনটে হবে
be
ফ্রেমিং is
proceeded with analogously.
I'm grateful. Extremely grateful.
Madam, I am led by Mr. Jagdish Mukherjee, my lord.
So what can I do?
Name may be recorded.
I do not know.
Yes.
If he is outside, then
No, my lord, he is another court, my lord, engaged, my lord.
whatever it may be. Now, if he goes outside or anything, he is not available. In spite of that, you are.
I have no objection for the record, my lord. I'm sure.
Doesn't matter. Okay, যা দেবে দিয়ে দাও। যদি এখানে থাকে, যদি কোর্টে থাকে তবে কিন্তু, নাহলে কিন্তু খুব মুশকিল হবে।
execution cases item number 8
ডিসমিস করে দিই। হ্যাঁ, কি করে অর্ডার হয়েছে কিছু? হ্যাঁ, যার অর্ডার। It appears that এইভাবে লিখুন। None appears on behalf of the petitioner on repeated listing of matters. Stop. However, for ends of justice, list the matter on Monday. As peremptorily, as a last chance, as a last chance. And if the petitioner does not appear, then this court will be constrained to dismiss the present application. Yes. Very easy. কেন না, হ্যাঁ পিটিশনারই তো হবে, কেন তো একটু মনে করিয়ে দিও এক্সিকিউশন কেস আর টেস্টামেন্ট এত পাশাপাশি হচ্ছে মাঝে মাঝে। হ্যাঁ হ্যাঁ ঠিক আছে, এইটা মনে রাখতো। হ্যাঁ এটা তো দিতেই হবে। ঠিক আছে। হ্যাঁ আস্তে আস্তে, হ্যাঁ ঠিক আছে নাকি? ঠিক আছে।
মানডে হচ্ছে 11th March item number 9
I'm for the degree holder, my lord, in this matter.
And who is for the other side?
I'm not very sure, lordship. But then I think they have neither complied the degree passed by this court only. Neither they complied the degree, nor they filed at least the affidavit of asset, or nor they ever said that we are willing to. And the degree was a contested degree. It's not like that the ex parte degree, so they are not aware of. It was a contested degree, and that too a degree judgment upon admission, lordship.
Yes.
So it's a degree
12.
judgment upon, yes, lordship. Order 12 rule 6. Lordship, judgment upon admission, they contested, they preferred an appeal, then they lost the appeal, lordship, then execution. It was filed in the year 2021-22. That time we could not much pursue the matter. And in 23, lordship, last two orders, lordship will see that they have not contested. Lordship, a direction that they must They must appear, and apart from that, they must file their affidavit.
Whether they have initially appeared in this.
ওয়ানটা দেখো তো একটা অর্ডারে অ্যাপিয়ার করেছো প্রথম হ্যাঁ I think they have appeared.
None appears on behalf of the parties. This is an application for decree such and such. Secure the separate interest bearing.
চলো
Yes, somebody was there.
Of course, they are suffering the degree, they will play hide and seek lordship. But then
Yes.
if lordship direct them to file the affidavit of asset, it will not affect any of them, whether they can satisfy the degree or not.
The learned counsel for the decree holder has submitted that the judgment debtor is not complying with the direction of the court, nor he is paying anything as per the impugned decree. Stop. He has paid for issuing necessary direction to the judgment debtor. Stop. Para. It appears from the record that initially the judgment debtor has appeared in this proceeding, but thereafter the judgment debtor remained absent. Remained absent. Stop. Para. Considering all the aspects of the matter, the judgment debtor is directed to furnish affidavit of assets within a fortnight. Stop. This is the matter after 15 days. The learned counsel for the decree holder is requested to intimate this order. to the
Kindly
learned
make it
counsel.
directed. Kindly make it.
Is directed. Counsel of the judgment debtor.
21st March.
Lordship is fixing a date after
21st March.
21st March. Obviously.
Item number 10.
Is a section 47 application. Today we mentioned it is the recalling application appeared before the other court, and it has been fixed on Friday. Kindly keep it this application after some days, so that
Recalling application. Recalling application
recalling
before the trial court.
before the first court. Yes.
Yes.
My learned friend was there. Mr. Mitru was there. Oh, Sinha and Mr. Mitru were there.
Yes. এটা কি রেকর্ডটা দেখি আরে আগের দিন অর্ডারটা দেখি
May I humbly submit this, my lord?
Yes.
Kindly, my lord, keep this matter, my lord. Wednesday week, we can try our luck in the other court next week.
So you have already concluded, you are about to complete your submission.
Yes, but at that point of time, your lordship was pleased to observe that application is pending. And in fact,
In your presence,
in
that
my
order was
presence.
present.
Yes.
You are taking that virtual presence, but that is.
And the hurdles are there. That's why, my lord, I have been briefed.
So you
Kindly
are about
keep
to
it,
complete, I think, then
kindly
again,
keep it when the position will not alter if my application is dismissed. Yeah.
you are sure that the matter will be taken up on Friday or something like
We shall try our best.
Yes, Mr.
So only thing, I don't stand in the way of my learned friend asking for adjournment on the ground that the other matter is pending in the court. Only thing is this one. First of all, my memory is very short. I will forget what argument my learned friend has been in the meantime. I don't know about your lordship. That is one. And second thing is, in the meantime, let them stay their hands, because what is happening is this: we don't have any stay in the matter. Execution application is pending, and in the meantime, my lord, they're selling their property. This is what I have alleged in my petition. But let there be
Are you selling?
In the meantime, I shall
they will
not
not
to
deal
take
with the
any.
properties in the
Kindly
meantime.
take my honor.
Let
No.
there be an order of they will not deal with the properties in the meantime. Then I
When
don't
it is
mind.
being submitted by Mr. Mitro, please do not take any step.
So you will not sell anything. Okay, you have undertaken.
Not undertaking, that may create problem. Kindly take a.
Your lordship can say that in the meantime they will not deal with any of the properties.
That may affect my business also. That may affect my business. So that's why I'm saying let us wait for 1 week.
And in the meantime, you don't sell off the properties. That's all for all that.
Yes. I
You're-
plead to it.
I'm sure your
Please
business is
instruct
not
client.
to dispose of the properties.
No.
The learned counsel for the petitioner, within bracket defendant, in the application under section 47 Code of Civil Procedure, 6 for an accommodation, as he has received instruction to proceed with the recalling application before the learned trial court. Stop. The learned counsel has sought for an accommodation for 7 days. Stop. Para. The learned counsel for the decree holder,
Fortnight, I think.
decree holder has submitted that he has no objection to such adjournment petition, provided the judgment debtor oblique the petitioner shall not take any steps to sale of any of the immovable properties in connection with the matter. Stop. But, instead of 7 days, 15 days. Okay. 15 days করে দিন তো. Stop. Stop. Para. In view of such submission, release the matter after 15 days. Stop. In the meantime, the petitioner, within bracket defendant, in the application under section 47 CPC, shall not deal with the immovable properties, shall not deal with or shall not sell.
Shall not deal with or dispose
Shall
of.
not sell with, I
Shall
can't
not deal
read
with
there.
or dispose of
Dispose of
with any of the immovable properties in connection with the matter.
in the meantime.
Kindly omit the expression deal with.
Okay, dispose of.
Dispose of.
Dispose of.
Accepting in the usual course of business. তাই করে দাও তাহলেই হবে।
Accepting
Accepting the usual course of business. চলো না, তুমি তোমার
any of the immovable properties, accepting
in the usual course of business.
Accepting in the usual course of business till further order. In the meantime, to বলেছি না?
Well, one thing can be done for the protection of both parties. If they want to deal with any of the properties, then they will give a notice to us.
That is always there.
After 15 days, you come back.
Yes.
Very well. If you come to know of it, then
Yes, yes.
I don't think there will be any urgency to that effect.
Okay. Till further order. না, in the meantime বলেছি তো। in the meantime তাহলে till further order বলার দরকার আছে কি? এখন থাকুন, তারপরে যদি মনে হয় তখন আমি একটু কারেকশন করব।
তারপরে
সিনিয়র অ্যাডভোকেটস
তাহলে বলে নিন। আচ্ছা ঠিক আছে।
এই একটা ডেট দিয়ে দাও।
28th.
ওকে।
কিছু আছে ঠিক আছে।
হয়ে গেল আইটেম নাম্বার ওটা তো 12টার সময় আছে
হ্যাঁ ওটা 12টার সময়।
ফর হিয়ারিং আইটেম নাম্বার 12 and 13
ও এটা yes.
Hello,
My lord, it is my lord.
Yes,
my lord, she want to join via
I can't hear
online
you,
mode.
madam.
I'm for the defendant number 1.
For the defendant number 1, what is the name of the defendant number 1?
Prasun
Prasun.
Kumar Bhattacharya.
Prasun what? Prasun? Prasun?
Prasun Kumar Bhattacharya.
Prasun Kumar Bhattacharya. You are appearing on behalf of Prasun Kumar Bhattacharya.
Defendant number 1A.
Yes.
Actually, my learned senior want to join via online mode.
আগে অনলাইনে
Senior counsel.
নেই
She want to join via
Virtually.
online mode.
What is it? Virtually he will appear. She will appear.
I think, my lord.
কি বলছে দেখো তো? হ্যাঁ সেটা আমাদের yes.
My lord, kindly recall, my lord. It is
All
my lord.
parties here.
Yes.
You are for? What is the name?
Defendant numbers 2C, my lord.
Bhattacharya.
My lord.
And
That's even noted.
and Miss Mukherjee. Mrs. Mukherjee, learned counsel. You.
She's
She's
for
not
the-
there. So you are here. Okay, no problem. You take down notes. এই আমার একটা আছে মোটামুটি এটা হ্যাঁ 12টা অব্দি চলবে সোমেশ ভট্টাচার্য
Yes.
কথা হলো সব কথা হয়েছে
My lord, kindly recall, my lord, in this matter, my lord, this present application has been filed by the defendant number 1A. After, my lord, the decree was passed in 2009.
Decree was passed in
2009.
2019.
2009, my lord.
2009.
A compromise decree.
Compromise.
Yes. It has been alleged for the first time that there has been a fraud. When, my lord, the predecessor in interest of the present applicant never, my lord, brought this fact before this learned court. Even when he filed, my lord, section 47 application, which was being dismissed by the executing court.
You are Mr. What is your name? Good name, please.
Deep Narayan Mukherjee, my lord.
Deep Narayan Mukherjee. Yes.
I have, my lord, placed judgment relying that if they want to challenge the legality or validity of the decree, my lord, they have to approach before the court which passed the decree.
Separate suit.
Yes. And that is, my lord, barred under Order 23, Rule 3A. My lord, kindly takes the code once.
Order 23.
Rule 3A.
Just a minute. Part to suit.
Yes, my lord.
No suit shall lie to set aside a decree on the ground that the compromise on
Yes.
which the decrees based was not lawful.
Yes, my lord, the hands of this executing court are tied, my lord. The executing court in March 2023, my lord, passed a judgment by giving certain direction as per the tabular statement on defendant number 1ABC to, my lord, execute a deed of conveyance as per the compromise decree. After, my lord, passing of that judgment, an appeal has been preferred. My lord knows, my lord, that appeal is pending before the Honorable Division Bench. That is running in the list, my lord, even today.
Who filed the
Defendant number 1B.
Against which order?
Against the judgment dated judgment which was passed in March by the executing court.
Judgment
2nd
dated,
March.
Judgment dated 2nd March 2023.
Yes, in this present execution proceeding.
The present execution proceeding was challenged by one of the
heirs of the, my lord, the original defendant number 1.
The heirs of the
another brother of the applicant, my lord, from the same branch.
What was the judgment dated 2/3/2023? I want to see.
Ekটু judgment account.
You please inform me.
Xerox করা ছিল।
And the said appeal, what is the number of the said appeal?
My lord, it was not in appeal, it was in the present execution. The appeal.
No, judgment dated 2/3/2023 in the present execution case was challenged by one of the heirs.
Yes.
By filing appeal.
Yes.
What is the number?
APOT number 78 of 2023.
Being APOT number. Yes, APOT number
78 of 2023.
78 of 2023. And that is pending.
My lord, there no stay has been granted in the appeal.
And no stay has been granted. Now, I want to see the 2nd March order, judgment.
Yes.
Yes.
My lord, kindly straightway comes to page number 17. 17 of the judgment.
17 of the judgment.
Yes. Paragraph 21 onwards.
Para
21 onwards.
Para 21.
Yes. May I, my lord, read out?
Yes.
The Honorable Division Bench observed, my lord, kindly note, my lord, this, my lord, GA 1493 of 2010 was filed by the original defendant number 1, questioning the legality and validity of the decree. And my lord, that was carried to appeal. My lord, may I read out? The Honorable Division Bench observed that the defendant number 1 filed GA number 1493 of 2010 for setting aside the compromise decree dated such and such, but it was dismissed by the Honorable Single Judge on 7/3/2011, which was further challenged in appeal, being APOT number 106 of 2011, which was also dismissed on 21st May 2011. Accordingly, the Honorable Division Bench refused to determine such question for setting aside the decree dated 19/12/2007. Honorable Division Bench only took up the question of validity of the order dated 14/9/2010 passed by the learned single judge, refusing to review the earlier order dated 27th August 2010, directing the submission of plan to the municipal authority. In this regard, the Honorable Division Bench observed as follows. My lord, then then the relevant portion from the appeal court's order, my lord, is, my lord, quoted. We do not think that the learned single judge had committed any error by directing the defendant number 1 to submit a plan for sanction by the corporation. Whether that plan could be sanctioned in accordance with law is something that was within the domain of the officers of the corporation. It was not for the court to consider whether the plan which the defendant number 1 proposed to submit was as per building rules and regulations. It is obvious that only a plan which is accordance with law can be sanctioned by the corporation. If the plan submitted by the defendant number 1 is not sanctioned, it is for him to adopt appropriate steps to remedy the situation, either by challenging the order or by submitting a fresh plan. We have noticed that time and again the division bench of this court has passed order to ensure that the settlement without prejudice being caused to any of them. The division bench had directed the defendant number 1 to submit a plan as to make Lot B habitable. It appears, however, that the defendant number 1 submitted a plan which was for construction of a new building on Lot B, and it is in the circumstances that the competent authority refused to sanction the same. The import of the order dated 24th February 2011 passed by the division bench of this court is unambiguous, inasmuch as the plan which the defendant number 1 was submit was for the construction of a staircase, a kitchen, a water reservoir and a toilet in Lot B, which fell to the share of defendant number 1. Under the consent terms, instead of submitting such a plan, defendant number 1 submitted a plan depicting the construction of a building at the rear end of Lot B and for connecting the same to the existing structure. In this case, the circumstances, the sanction for such construction was denied. We do not therefore think it is necessary to consider whether the consent terms are legal and justified, as the compromise decree has been passed. There was a challenge to the compromise decree by the defendant number 1. He sought revocation of the decree. The learned single judge, having failed to pass any order on that application in favor of the defendant number 1, he filed APOT 106 of 2011, which has been dismissed. In the circumstances, we do not think that the order which has been passed in GA number such and such on 14 September is illegal, and therefore the appeal is dismissed. My lord, then my lord, the appeal was dismissed, which was, my lord, preferred by the original defendant number 1, challenging the legality and validity of the compromise decree. Then, my lord, I have filed this present execution case. The defendant number 1 filed a section 47 in the present execution, my lord, which is quoted in paragraph number 25 at page number 20. My lord, may I read out?
What is the name of the defendant number 1 here?
The original defendant number 1 expired in 2019. Now, my lord, he has been substituted by his 3 sons. Proshun Kumar Bhattacharya, Pratik Bhattacharya and Partho Bhattacharya. The original defendant number's name was Pran Kumar Bhattacharya. My lord, may I read out paragraph number 25 at page number 20? A dismissal order of section 47. All the issues raised in application under section 47 of the CPC were addressed by the Honorable Justice IP Mukherjee in GA number such and such in connection with this execution case. The Honorable Single Bench dismissed the application under section 47 of the CPC by an order dated 16th of November 2015, which runs as follows. My lord has got it. A decree was passed on 19 December 2007. It was a compromise decree. It was for a partition of a premises number 88 by 2A, Rafi Ahmed Kidwai Road, Kolkata, along with other properties. An application for execution was taken out by the plaintiff for execution of the decree. Another application, being GA number such and such, under section 47 of the Code of Civil Procedure, was filed by the defendant number 1, namely Pran Kumar Bhattacharya. My lord, the original defendant number 1. In this execution application, various points have been taken on behalf of the said defendant to challenge the decree. First, it was stated that it was not a final decree, but a preliminary or a part decree. Secondly, it was stated that the decree was inexecutable. My lord, the same point taken in this application, that, my lord, the decree is inexecutable. It was submitted that the decree provided for division of the premises into Lot A, Lot B, Lot C. Lot B had fallen in the share of defendant number 1. Lot B was not habitable. The decree provided for some constructions to be made. Therefore, unless those constructions were made according to the choice of the defendant number 1, the decree could not be executed. Mr. Bhattacharya, learned counsel, submitted that the portion which fell in the share of defendant number 1 did not provide for a bathroom, kitchen, staircase, etc. Other ancillary points were taken, namely that the decree was not drawn up according to the terms of settlement. The heirs of the defendant number 2 has not been substituted in the execution application, was not in proper form. As far as the substitution of the heirs of the defendant number 2 is concerned, this court noted in an earlier order that no substitution was required if a party died after the decree. It was carried in appeal. The appeal, I am told, was dismissed. As far as the first ancillary point is concerned, I think it has no substance. A certified copy of the decree is annexed to the execution application. Furthermore, a party to a compromise decree cannot, in my opinion, turn around and resist execution thereof. On the above technical point that a certified copy of the execution application, it was the obligation of the defendant number 1 to supply a certified copy thereof to facilitate execution. I have scrutinized the execution application and hold that it is in proper form. In my opinion, this matter has been unnecessarily prolonged for a considerable length of time before this court because of the resistance of the defendant number 1. It has also spent similar time before the Court of Appeal at the instance of the same party. The decree is a compromise decree for partition. The reference to construction in the said decree only refers to those construction which would make each of the partition parts of the premises independent and capable of separate enjoyment. In my opinion, the decree does not provide for making any substantial construction as the defendant number 1 has indicated in his proposed plan. Substantial construction may be carried out by one of the parties only after partition in terms of the decree, in my opinion. Furthermore, the import of expression of construction to be made in the premises was considered by the division bench of this court in its judgment, and the order dated 10, the earlier order, my lord, I have placed before your lordship, the order passed by the appeal court, where the division bench explained the following, my lord. Then the order was quoted from the division bench. Most importantly, my lord, the next page, second paragraph, most importantly, the defendant number 1 has received rupees 10 lakhs from the plaintiff for agreeing to take Lot B under the decree. Furthermore, he is entitled to further amounts as well, having so agreed by signing the compromise and having acted upon it. The defendant number 1 is stopped from challenging the decree itself as inexecutable. I come to a conclusion, there is no defect in the decree whatsoever which makes it inexecutable. Hence, the application under section 47 of CPC is dismissed. My lord, then my lord, the next page, my lord, page number 23, paragraph 26. Therefore, all issues raised by Mr. Bhattacharya have been duly addressed and disposed of either by the Honorable Division Bench or by the single bench of this court. Those orders remained unchallenged. Finally, the issue raised by Mr. Bhattacharya was also taken up by the Honorable Single Judge in connection with GA number such and such, in connection with an application under section 47 of the Code of Civil Procedure, and that order also remained unchallenged. In the aforesaid view of the matter, I am unable to reopen the issues raised by Mr. Bhattacharya again before this executing court. Nothing is left to this executing court but to issue direction towards execution of the decree. My lord, this order was passed, this judgment was passed on 2nd March 2023. Certain directions were given to the defendant, substituted defendant number 1. Then, my lord, again, a challenge to the decree has been made by the substituted heirs by taking plea of fraud. My lord, on the last occasion, my lord, I have submitted, assuming, my lord,
plea of fraud was new one.
Yes, yes.
So
his father, who was originally the party to the compromise, never raised the issue. This is absolutely a new issue before this executing court.
But his father is a party to the fraudulent activities as alleged.
Whether, my lord,
I am not.
a question of fraud can be determined by the executing court. This is my humble submission, my lord. I am covered by a special bench judgment of Supreme Court, my lord. May I place the judgment? It is an unreported
So
judgment. my lord.
against this judgment, this appeal is pending. Against this.
Yes. It is, my lord, an unreported judgment, my lord.
Unreported.
Yes. A 3-bench judgment.
Have you submitted copy? Your
It a judgment dated 12 January 2024. My lord, we find that in page number 35 of the judgment.
judgment. Date is not here in the first page.
My lord, date is appearing in the last page, my lord. Page number 35 of the judgment.
January.
May I have your lordship, please?
Yes.
Have your lordship. May I come back in 10 minutes?
Yes.
Asma Latif and Hon'ble versus when, my lord, executing court, can my lord look into the legality or validity of a decree? My lord, in this case, my lord, there were 3 defendants, my lord. One of the defendant filed his written statement in the suit under which was filed under section 34 of the Specific Relief Act. And my lord, thereafter, my lord, that the original defendant number 1 died. The other 2 defendants, my lord, did not file any written statement. It was held, my lord, by the Supreme Court that the original defendant number 1, as he taken the point of maintainability of the suit in his written statement, though, my lord, the original defendant number 1 was not substituted, and my lord, the suit abated against defendant number 1, the suit was decreed against defendant number 2 and 3. The Supreme Court held that when the question of maintainability was taken by one of the defendant in the written statement, it has to be, my lord, first determined by the court. Court cannot look into the merit without going to the maintainability question. Even, my lord, while passing an order of injunction, court has to look into the maintainability question. My lord, my submission is whether this executing court can look into the maintainability question of the decree. When, my lord, it was not passed without jurisdiction. There is no plea that it has been passed by a court which lacks jurisdiction. Whether the executing court can entertain when it is not a nullity. My lord, kindly comes to paragraph number 12 straight away. My lord, may I give the citation, my lord? It's 2024 SCC online.
2024.
Yes.
Then you have said that unreported.
My lord, I have just now found out, my lord.
2024.
SCC online. SC 42.
42.
My lord, kindly comes to paragraph 12. At, my lord, page number 12. I will not travel your lordship through the whole judgment, my lord. I am only citing, my lord, the relevant portions. My lord, may I read out? The sole question of law which arises for a decision in this appeal is whether the order dated 5th August 1991 suffered from a jurisdictional error so grave that the decree drawn up subsequently is incapable of execution by the executing court, and an objection that it is inexecutable was available to be raised under section 47 of CPC by the respondent number 1 to 3. Then, my lord, kindly comes to paragraph number 23.
Para 12,
Yes.
then 23.
Then 23, my lord. We find close resemblance of the fact and circumstances under consideration of such and such. A money suit was instituted by the respondent before this court was tried by the High Court at Calcutta. After taking evidence, the learned single judge on 17th August 1962 passed the following order. There will be a decree for rupees 15,000 with interest on judgment on rupees 15,000 at 6% per annum, and cost no interim interest is allowed. Pursuant to that order, a decree was drawn up. An appeal carried from the decree before the division bench failed. The division bench assigned sketchy reasons for the conclusion that the trial court rightly decreed the suit and disposed of the appeal with certain modification of the decree, while allowing the appeal and setting aside the decree passed by the High Court and remanding the suit to the court of first instance for trial according to law. This court noted Order 1 Rule 8 of Order 20 CPC are by the express provision contained in Rule 3 Sub-Rule 5 of Order 49 CPC is inapplicable to the Chartered High Court in this exercise of its ordinary or extraordinary original civil jurisdiction, and hence a judge of a Chartered High Court was not obliged to record reasons in a judgment strictly accordance to the provision contained in Order 4 2 and 5 of the Order 20 CPC. Notwithstanding such provision, this court proceeded to record in paragraph 6 as follows. Trial of a civil dispute in court intended to achieve according to law and the procedure of the court of a judicial determination between the contesting parties of a matter in controversy. Opportunity to the parties interested in a dispute to present their respective cases on question of law as well as fact. Assignment of facts by means of evidence tendered by the parties and adjudication by a recent judgment of the dispute upon finding on the facts of controversy and application of law to the facts found are essential attributable of judicial trial. Yes, in a judicial trial, the judge not only must reach a conclusion which he regards as just, but unless otherwise permitted by the practice of the court or by law, he must record the ultimate mental process leading from the dispute to its solution. A judicial determination of a disputed claim where the substantial question of law or fact arise satisfactorily reached only if the supported by the most cogent reasons that the suggest themselves to a judge. A mere order deciding the matter in dispute not supported by reasons is no judgment at all. Recording of reasons in support of a decision of a disputed claim serves more purposes than one. It is intended to ensure that the decision is not result of whim or fancy, but of a judicial approach to the matter in contest. It is also intended to ensure adjudication of the matter according to law and the procedure established by law. A party to the dispute is ordinarily entitled to know the grounds on which the court has decided against him, and more so when the judgment is subject to appeal. The appellate court will then have adequate material on which it may determine whether the facts are properly ascertained, the law has been correctly applied, and the resultant decision is just. It is unfortunate that the learned trial judge has recorded no reasons in support of his conclusion, and the High Court in appeal merely recorded that they thought that the plaintiff has sufficiently proved the case in the plaint. My lord, it is absolutely, my lord, not the case that the decree was not passed and drawn up by this court. Absolutely not the case. A compromise was entered into by the parties, by and between the parties. They filed the compromise, my lord. According to the compromise, the suit court filed the decree. And my lord, in this execution application, my lord, it is not the case of the applicant that it was passed without any jurisdiction. It was the contention of the defendant number 1A that has a fraud has been played on court. Whether, my lord, a fraud has been played on court or not, that is the subject matter of trial. Executing court, after, my lord, the judgment dated 2nd May 2020, 2nd March 2023, has become functus officio. It is, my lord, only pending for compliance. Yes. My lord, kindly comes to paragraph 26 of the judgment. It is very important, my lord. At page number 21. Reference to couple of authorities on the scope and nature of section 47 of CPC at this stage would not be inapt. In, my lord, judgments was cited. This court was considering the scope of objection under section 47 of the CPC in relation to the executability of the decree. Therein, it was laid down that only such a decree could be the subject matter of objection which is a nullity, and not a decree which is erroneous either in law or in facts. Law was laid down in the following terms. A court executing a decree cannot go behind the decree between the parties or their legal representatives. It must take that the decree according to its tenor and cannot entertain any objection that the decree was incorrect in law or in facts, until it is set aside by an appropriate proceeding in appeal or revision. A decree, even if it to be erroneous, is still binding between the parties. When a decree is a nullity, for instance, where it is passed without bringing the legal representative on the record of a person who was dead at the date of the decree, or against a ruling prince without a certificate, is sought to be executed, an objection in that behalf may be raised in a proceeding for execution. Again, when the decree is made by a court which has no inherent jurisdiction to make objection as to its validity, may be raised in an execution proceeding if the objection appears on the face of the record. Where the objection as to the jurisdiction of the court to pass decree does not appear on the face of the record and requires examination of the question raised and decided at the trial, or which could have been but not been raised, the executing court will have no jurisdiction to entertain an objection as to the validity of the decree, even on the ground of absence of jurisdiction. My lord, this executing court in execution, my lord, is not, my lord, it is my respectful submission, my lord, is not sitting as appeal court to stay its own order. An appeal has been preferred. Appeal court, my lord, did not grant any stay. The appeal court in active season of the matter. Appeal court has, in pursuance of the directions given by the appeal court, the 88/2A, the premises in question, has got, my lord, 3 different premises numbers. It has been partitioned, it has been demarcated. Now, my lord, they are coming before the executing court saying that the decree is void. Can this question be raised before executing court?
The premises 82.
Yes, 88, it was formerly, my lord, 88/2A. Now it has got, my lord, 3 different numbers as per the direction of the appeal court.
The number in
88 by
premises, in three premises.
my lord, originally it was 88 by 2A. The original premises number was allotted to defendant number 1, legal heirs of the defendant number 1. The 88 by 2A by 1 has been assigned to the plaintiff, Somesh Chandra Bhattacharya. And my lord, 88 by 2A by 2 has been assigned to the legal heirs of the defendant number 2.
Yes.
Now, my lord, what is left with the executing court to determine?
What about defendant number 1?
Defendant number 1, my lord, the legal heirs of defendant number 1 has assigned to the premises number 88 by 2A. The original premises number has been assigned to them.
So when this assignment of different number can be done unless the property is demarcated?
My lord, it has been done. It was my lord, a receiver was appointed in this execution application, my lord, who has been, my lord, demarcated the property by way of pegging as per the order of the executing court.
Hey,
my lord, may I hand up the order?
কি হয়, কৌশিক কি হলো তোমার এক্সামিনেশন অফ শেষ করি এসছে? Yes, Mr. Mukherjee. We have a special bench now.
My lord,
assigned matter, huh? At 12 noon. Fixed matter. So you come back tomorrow?
Tomorrow, my lord. My lord, can it be day after?
Yes, why not?
My lord, tomorrow. Very well, tomorrow.
Planet counsel for the decree holders.
My lord, I will not take, my lord, more than 10 minutes.
As resumed,
I'll
yes,
start
yes.
start thereafter. For the defendant numbers 2A, 2B, 2 and I'll be adopting most of my learned friend's submission. I'm supporting him, but I've some
Okay,
more
okay.
to say.
Come back tomorrow.
Right.
Planet counsel for the decree holder has resumed his argument, resumed his submission, but does not conclude. Please the matter, কালকে date with you. 7th March. বারোটা পনেরো থেকে আমরা সমস্ত দুটো করে হবে, আর একটা 12টা 15 থেকে আর একটা 12টা 45, দুটো থাকে, দুটোর বেশি হবে না।
Noon fixed matter, item number 11.
Appear for the decree holder.
Yes.
This is one for the cross examination of the judgment data.
You come earlier?
Yes.
This is the second time or
Third time.
third time? What's your name?
Surendra Singh Bengani.
Surendra Singh Bengani.
Surendra Singh Bengani.
They started, I think, no?
Yes, second time.
Third time.
No, not second time, third time.
Please go slow. Whatever you know.
Yeah. Mr. Bengani,
Yes,
when have you come from Delhi for today's matter?
yeah.
When? When have you reached Delhi?
Yesterday,
How have you come from Delhi?
by train,
What is the name of the train?
train Rajdhani.
What was the timing from Delhi and when it has reached Kolkata?
Yesterday at 10 o'clock. Yeah, 10:30 yesterday.
10:30
Morning.
morning or
Morning.
and when has it reached?
It reached yesterday 10:30. 10:30.
It was yesterday 10:30 and you have reached in
No, it started on a day before yesterday at 4:30. 4:30.
Started on day before 4:30. Which 30 what? PM or AM you have to write. PM or AM?
Reached yesterday. 30 in the evening, in the afternoon. Started on day before 4:30. Day before yesterday. Day before yesterday. At 4:30 in the afternoon. And reached
4:30 evening হয়ে গেছে 4:30
in the evening. In the evening. And reached Kolkata at 10:30 yesterday morning. Yesterday morning.
Mr. Bengani, I am showing you extract of the case status obtained from the official website of this honorable court. Kindly go through the same and tell my lord that what are these matters all about.
What are these matters?
All about.
ये तो डेटर और क्रेडिटर्स का केस चल रहा है उनका है. These are the case which are going on between the debtors and the creditors.
Are you okay?
हाँ.
Are you involved in these matters?
Yes.
How are you involved in these matters?
रुपया दिया हुआ है और लिया हुआ है तो इन्वॉल्व तो होगा ही ना. Money has been exchanged, so I am involved with that matter.
Kindly count and tell my lord how many matters are pending only in this court and pursued by you.
Only one case.
Are you sure? Are you sure after looking into the
नहीं,
case status?
इस कोर्ट में तो ये एक ही केस है और कोई है नहीं.
Don't play smart. Kindly see.
आप देख लीजिए ना जितना है वो गिनती कर लीजिए.
I am asking you to count page by page how many matters are pending in your name.
आपका नाम से कितना मैटर है?
Count it.
इसमें कितने मैटर्स में आप इन्वॉल्व हैं? पूरा देखिए फिर बताइए. ये सब में ही है.
Count it. How many matters?
गिन रहा है.
हाँ गिनिए. हाँ. Involved and pending before this honorable court. As on today করে দিন.
17 केस.
17.
I put it to you that there are 25 cases pending as on date where you are involved before this honorable court only.
25 केस है. तो हाँ, तो जो केस 2 बार ना नीति में आएगा उसको तो एक केस को अगर 2 जगह आएगा तो उसको 2 जगह थोड़ी गिनेगा, एक जगह गिनेगा. If one case is present in 2 places, then it should not be counted as 2 cases. Counted twice. Counted twice.
Are you being represented by lawyers in all those cases?
Yes.
Who are your lawyers?
Virendra Singh Bengani.
Virendra Singh Bengani.
So do I take it that only Mr. Virendra Singh Bengani is involved as your lawyer and no others?
Other Mr. Rohit Banerjee.
Other one is Mr. Rohit Banerjee.
I am showing you one each orders passed in all these matters by this honorable court. Kindly go through the same and tell my lord that other than Mr. Rohit Banerjee and Mr. Virendra Singh Bengani, are there any advocates who had been representing you in any of these matters?
एक बार में
आप देख लीजिए.
रोहित बनर्जी और
एक बार दूसरा वाला काउंसिल को खड़ा किया था.
one another
Other than Rohit Banerjee or Virendra Singh Bengani, is there any other advocate representing you in any of the matters?
तो उससे क्या फर्क पड़ेगा, कोई भी एडवोकेट हो.
Don't ask me question. I am asking you question.
हाँ तो मैं भी तो जवाब दे रहा हूँ ना.
तो जवाब दीजिए. Don't ask me question.
हाँ.
Okay, who is the learned counsel for the judgment debtor? Please ask your witness.
Don't get excited. I am asking you. No. Why should I show you? I will not show you.
He is not so competent to understand.
So you are not there to assist me. Please sit down, sir.
No, I am asking him to ask his witness.
My lord is only asking to mellow him down.
Who has appeared? Bengani and Mr. Rohit Banerjee. Find out and write down the name of the
It is not for you to understand, sir. It is for him to understand. You are not supposed to understand.
He may not be aware, Rohit.
He may not be aware.
May not be. Every time he was not in the court.
Then he will not answer that I am not aware. Let him answer, please. Don't assist him.
मेरे को पता नहीं है ना. मेरा एडवोकेट ऑन रिकॉर्ड खड़ा होता है. वो किसको खड़ा करेगा, वो एडवोकेट ऑन रिकॉर्ड जानता है.
And he is giving clues.
Please.
You go through it and tell who have been appearing on your behalf.
रोहित बनर्जी, SS बुतोड़िया, वीरेंद्र सिंह बेंगानी, आर घोष, नहीं ए पाल.
My lord, that A fag has by mistake has been written.
I
don't
my lord,
know.
kindly ask him not to interject like this.
Please take your seat, sir.
That's all.
Yeah.
So you just replied to my last question that you have only engaged Mr. Virendra Singh Bengani and Mr. Rohit Banerjee. But in the answer to the to this question, you have at least taken name of 4 different advocates, two other advocates apart from Mr. Rohit Banerjee and Mr. Virendra Singh Bengani. I am putting it to you that you are lying in answer to every question.
The first questions you have asked two names.
He has given name of 2.
Thereafter, you have placed that document to show
that who are the advocates have been appearing on his behalf.
After then it should be recorded that document is handed over to the
Yes.
witness
Achha.
after perusing this.
After perusing, তাহলে ওটা record করুন।
Please take your seat. I know how to deal with all this.
তাহলে ওটা যশা যেভাবে বলছেন ওটা করুন।
Second যেটা অ্যানসারটা হলো না,
the document
ওখানে একটা ব্র্যাকেটে লিখতে হবে।
The orders are being handed over.
হ্যাঁ, orders are being handed over to the witness, bracket closed. Then his answer will be recorded. Okay, that means after perusing the orders,
he is answering. Absolutely correct. Then তাহলে আগেরটা এটাও যাবে ওই যখন
document also.
this should also case status.
Whenever a document is produced and is being given to the witness, it should be recorded first. Such and such.
Absolutely.
Then, okay. Next question.
ওই যেখানে গুণে বললো 17টা সেখানে যে witness shown case status. Documents downloaded from the case status of the portal of the Honorable High Court at Calcutta. ওটা খালি ব্র্যাকেটে লিখে দিন।
ব্র্যাকেটে লিখে দিও তবে then
from the official portal of the Honorable High Court at Calcutta.
Now this question does not lie. Lying we should understand. Okay.
Yes.
Now you come to next.
তাহলে একটু ওটা রিপিট করে দিন যে সাজেশনটা দিচ্ছিলাম।
ওটা করছিলেন আপনি, you have just replied to my last question that you have only engaged Mr. Virendra Singh Bengani and Mr. Rohit Banerjee. But in answer to this question, you have at least taken name of 4 different advocates.
Two other advocates.
2 different other advocates.
Apart from Mr.
Rohit Banerjee and Mr. Virendra Singh Bengani.
Full stop.
I'm putting it to you that you are lying
in answer to every question.
जावे तो आपको ये कहा कह रहे हैं कि अभी पहले आप जो दूसरा सवाल किए थे उसमें बोले थे कि बेंगानी आप और रोहित बनर्जी आप
सर
अभी इसको देख के आप बोल रहे हैं कि और
सर मैं तो केस देखता
तो ये आपका सजेशन है, मान भी सकते हैं नहीं भी हो सकते, आप इधर झूठ बोल रहे हैं। ये
मैं कोई झूठ नहीं बोल रहा हूँ। मैं हाँ और
that is sufficient. I'm not telling any lie. I'm not lying.
I am not lying.
So how are you pursuing this series of litigations before this honorable court on a day-to-day basis?
क्या नहीं समझा?
बेसिस पे यहाँ जो इतना मुकदमा चल रहा है, इतना केसेस चल रहा है, ये कैसे चला रहा है?
वो वीरेंद्र सिंह बेंगानी देखता है।
My advocate Virendra Singh Bengani takes care of all that.
How are you making payment of the remunerations of the learned advocates who are being engaged at least in 17 matters according to you?
So whether you will ask the amount also?
Because Millard, he has said that he has nothing. He is Kapordak Shunno. So 17 matters running in cause list every day.
Then we'll understand.
So
you may carry on. Okay. I'm afraid that you will ask the
How are you making payment of the remuneration of the learned advocates who are being engaged at least in 17 matters
according to you?
कैसे पेमेंट कर रहे हैं?
पेमेंट में हाँ तो 17 में तो सब तो हियरिंग में आता नहीं है, और जब भी वकील का खर्चा होता है मेरे पास होता है, मैं भाई को दे देता हूँ, और नहीं तो भाई देता है।
ठीक আছে।
All these cases not come all at a time for hearing, come up for hearing before the honorable court. All these cases does not come up for hearing at a time before this honorable court. Whenever I have money,
না, whenever the matter used to come up, I used to pay the fees to my brother. He said, हाँ, भाई को दे देता हूँ।
जब पैसा होता था,
ना ना ना,
मेरे पास
whenever the
जब
matter
पैसा
is
होता
come up.
था
whenever the matter used to come up,
Sir, please.
सर, मैं जो बोलता हूँ वो लिखेंगे क्या वो बोलते हैं वो लिखेंगे आप?
answer.
There are questions also where your name is also there. You will get more excited where your name is also there in the records. So you will get more excited. So please hold your breath for 2 minutes. I'll ask the questions.
He has said
Don't
that
exhaust
whenever the money
yourself.
is available
मैं
to me,
तो
I
जो बात मैं बोलूंगा वो लिखेंगे या वो
Your name are also there.
लिखेंगे आप?
Please have hold.
don't misinterpret the
Your name is also there. Kindly have your seat.
Yes,
You
yes,
please
yes.
hold your breath.
all these cases not come up for hearing at a time before this honorable court. Whenever the matter used to come up, whenever matters come up in the honorable court, I pay accordingly.
जब मेरे पास होता है मैं दे देता हूँ, नहीं तो नहीं तो मेरा एडवोकेट अपना एडवोकेट वीएस बेंगानी अपना पास से देता है।
Otherwise, whenever money is with me, I pay. Otherwise, my brother, who is my advocate also, Mr. Bengani, pays.
যেটা ডিসকাস করা ওই এফিডেভিটটা যেটা
আপনারা শুনুন, ভালো করে শুনে নিয়ে আপনারা নিজেরা করুন, নিজেরা করুন, অন্য কারোর হেল্প নেওয়ার তো দরকার নেই। আপনাদের তো এটাই করবেন।
একটু ডকুমেন্ট যেটা আগের দিন ডিসকাস করেছেন এফিডেভিট করে ওটা একটু দিন না। হ্যাঁ এটাই তো, হ্যাঁ ঠিক দিন। হ্যাঁ এটা দিন।
Affidavit upon by Surendra Singh Bengani.
Mr. Bengani kindly comes to page 4 of that document, of that affidavit, and tell my lord that who had represented you in this matter only, apart from Mr. Virendra Singh Bengani.
अनिरुद्ध मित्रा वीरेंद्र सिंह बेंगानी।
Anirudh
मित्रा
other than Virendra Singh Bengani.
अनिरुद्ध मित्रा and वीरेंद्र सिंह बेंगानी।
Other than Virendra Singh.
So in today's deposition only, you said that you are only being represented either by Mr. Rohit Banerjee or Mr. Virendra Singh Bengani and no other. So I put it to you that at least 3 different advocates have been representing you on a day-to-day basis, and whatever you are deposing is lie.
No, 2 questions cannot be asked. Only one. First question can be allowed.
Acha. Representing you on a day-to-day basis.
Yes. First question.
बोले थे दो
हाँ, क्या चीज? वो क्या पूछ रहे हैं मेरे को समझ में नहीं आता है। हाँ समझाइए।
आप पहले बोले थे कि आपको आपके तरफ से सिर्फ 2 ही वकील खड़ा होता है।
हाँ
एक है बेंगाली साहब और एक है
रोहित
रोहित
भाई।
भाई। अभी जितना रिपोर्ट किया गया उसमें निकला है कि 3 और भी वकील आपसे आपका केस में लड़ते हैं डे टू डे बेसिस।
सर ये 3 को देखिए कितनी बार प्रेजेंट हुए हैं, और मेरा एडवोकेट ऑन रिकॉर्ड का काम है कि कौन सा काउंसिल को खड़ा करेगा, मेरे को क्या मालूम कौन होगा।
If the documents are seen, then it will be found that advocates have appeared once or twice.
Only once.
And it is not in my knowledge
Uh,
that who is being engaged by my advocate on record.
So I take it that your learned advocate on record has no instructions from you, and he is instructing, have no instructions from you, and he is from his own will, is instructing learned counsels to appear on day-to-day basis on your behalf before this
क्या
honorable.
पूछ रहे हैं?
तो ये आप कहना चाह रहे हैं कि आपका एडवोकेट ऑन रिकॉर्ड आपको कोई बात बताता नहीं था कि डे टू डे बेसिस कौन सा एडवोकेट को एंगेज कर रहा है, ये आपको बताते नहीं थे?
नहीं, बात होता है, अब हम तो बोल देता है कभी जो जो ठीक लगे उसको एंगेज कर लो.
I always used to instruct my advocate on record that whoever thinks it and proper, you can kindly engage. It and proper, you may kindly engage.
So I take it that you have your consent on every engagement of learned counsel appointed by your learned advocate on record.
क्या
तो ये वो बोल सकते हैं कि आपका कंसेंट था जो भी काउंसिल एंगेज करे उसमें
consent.
Mr. Bengani, kindly tell this honorable court as to how you have made payment of these learned advocates as on 29th September 2023 of their remuneration or fees.
29 सितंबर 2023 को ये एडवोकेट का पैसा कैसे आपने भुगतान किया, पेमेंट किया?
वो एडवोकेट ऑन रिकॉर्ड देता है, मैं नहीं देता हूँ, और मेरे पास सुविधा होता है तब मैं उसको दे देता हूँ.
These payments were made by the advocate on record acting on my behalf, and whenever I had money, I used to hand him over. So, I used to give the money.
पे माने उसको दे देता हूँ, माने hand over to him.
Hand over.
So I take it that ultimately the money is being paid by you.
तो ये वो मान सकते कि पैसा तो आप ही से जाता था.
पैसा पूरा मेरा से पास नहीं है, मैं थोड़ा बहुत देता था, बाकी वो अपने पास से देता है, मेरा भाई है.
Not have the entire money. Whatever I had, I used to hand over. My advocate record used to pay, as he is also my brother. As he is also my brother.
Mr. Bengani, can you say roughly, not the exact figure,
Anumani.
till date in all these recent litigations, how much money has been already paid by you or expended by you for running all these litigations?
ये सब मुकदमा चलाने के लिए अब तक आप करीब कितना जो आपका
वो पता नहीं है, अकाउंट्स देखने से पता लगेगा.
I do not have that. I have to go to the accounts and then report. I have to go to the accounts and then report.
So I take it that you can inform this honorable court on the next occasion.
तो अगली बार जब आइएगा तब आप पता करके आइएगा तो
ठीक है.
Yes, I will.
But he is coming from Delhi and senior citizen is not well by health wise. So if all your lordship thinks it fit for another examination, it can be taken virtually.
No, not at all. It's not been provided in the rules to take it virtually.
Why not?
Don't ask me.
So he is praying before me. Why you are hearing that?
Oh, sorry.
Yes, what is your so he will complete that portion. Will be kept separate. Other questions he will put right now. Okay, please. Other chapter.
I'll try to complete.
Yes.
I'll try to complete.
Why you are so confining yourself also? If there are 17 litigations, you should leave there. Don't take it otherwise. That is sufficient. Now you are confining yourself. Don't take it otherwise.
No, no, very well.
When 17 litigations are pending in Honorable High Court, you should live there. You are confining yourself. You will bring some documents, then you will be bound by that. So, okay.
এফিডেভিটটা একটু তুলে দিন একবার। ওই এফিডেভিটটা
দেবো
হ্যাঁ দিন, ওনাকে দিন।
One second.
তিনটে বেঞ্চ আছে না ওখানে?
না, আমারটা গেল কোথায়? জাস্ট হ্যাঁ। Mr. Bengani kindly comes to page 6.
কি দেখাচ্ছেন?
Page 6
কি দেখাচ্ছেন
of the affidavit.
ওনার কাছে জেনে নেবেন যে কি দেখাচ্ছেন।
Page 6, page 6 নম্বর
by
ওই by him only.
প্যাকেটের মধ্যে লিখে তারপর ওটা দেখাবো।
Kindly comes to page 6 and tell my lord about your investments in shares which has been reflected in the balance sheet as on March 31, 2021.
कितना?
ये जो शेयर है ना,
What was your investment in shares
Investment कितना है?
शेयर में
as reflected on March 31, 2021?
45,06,300।
45 lakhs 6,300.
Kindly comes to page 7 of that affidavit and tell my lord that why it has not been reflected in the next year of March 31 of 2022.
ये सब illiquid शेयर था, राइट ऑफ कर दिया।
These were all illiquid shares. I had written them out. All illiquid shares. I have written them out.
सब डीलिस्ट हुआ हुआ शेयर था, डीलिस्टेड शेयर।
Were delisted from this. All these shares were delisted from the stock. Were delisted from the stock
exchange, तो उसको राइट ऑफ कर दिया।
So I had written them out.
अगर ये लेना चाहें तो इनको ट्रांसफर कर दूं मैं शेयर ये सब।
If the other side wishes, then other side wishes, I can transfer the share
in their DP account.
In their the shares in their depository account.
It should be recorded as volunteers.
Witness volunteers.
If the other side wants, I can transfer those shares in their depository account.
Kindly again come back to page 6 of the said affidavit and tell my lord about the unsecured loans given by you and what is the amount reflected therein.
The amount is 36 crore 28,04,132।
36 crores 28 lakhs 4,132 given by you.
सर आप क्रेडिटर्स का भी नोट कर लीजिए।
The creditors, the number of amount of the creditors shall pay the amount of the witness volunteer, pay the amount of the creditors. We also noted, which is
39 crore.
We also noted.
39 crore,
39 crores,
72 lakh,
72 lakhs.
58,000.
The amount of the creditors we also not. The amount of
39 crore,
9 crores,
72 lakh, 58,000, 145.
এটা কিভাবে লিখছেন আমরা 39 এতে লিখছেন না ফিগার লিখছেন না এতে what লিখুন 39 crore যেমন 39 crore then 72 lakhs in this fashion, otherwise there is a problem same like Devasis goes will happen. 39 you can write 39 then crores in words, okay, in this fashion, otherwise there is a zero there will cause some, okay, in this fashion, okay.
39 crores na lakhs হয়ে গেল।
Kindly comes to page 7 of the said affidavit and tell my lord as to what is the amount shown against unsecured loans given by you for the year March 31, 2022.
36 crore, 33 lakh, 21,000, 89.
So I take it that you have given loans for such gross amount from time to time to the creditors.
आपने लोन दिया है क्रेडिटर्स को टाइम टू टाइम,
हाँ
ये अमाउंट का
ये तो चल रहा है सर।
आपने दिया है कि नहीं?
हाँ हाँ दिया है।
Yes.
हाँ
That's it.
এক মিনিট। Mr. Bengani, kindly see question number 29. ডেপোজিশনটা আছে নাকি দেখুন, একটাই ডেপোজিশন দিয়েছিলেন ওই জাস্টিস ভট্টাচার্যের কাছে motion letter।
Twenty
29
हाँ 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 तो इसका जवाब तो दिया हुआ है ना।
you have deposed that you are a stock broker of SEBI by the name of Eureka Stock Share Broking Services Limited.
Yes.
Eureka Stock and Share Broking Services Limited.
I put it to you that there is no such stockbroking agency registered in the list of SEBI as Eureka Stock Share Broking Services Limited.
Eureka Stock and Share Broking Services Limited, ये सही नाम है।
Yes, the name is Eureka Stock Broking. आप प्रश्न समझे हैं?
क्या हाँ का वो बोल रहे हैं सेब से भी रजिस्टर्ड नहीं है। हाँ
Registered नहीं है।
है रजिस्टर्ड।
No, I deny.
हाँ
Registered.
सेब Eureka Stock and Share Broking Services Limited.
The stock
Eureka Stock and Share Broking Services Limited.
stock and share broking services. Limited.
Mr. Bengani kindly comes to
ये देखिए इसमें मिल जाएगा आपको यूरेका का नाम, ये सब रजिस्टर्ड है। ये पेज देखिए, ये सब इनमें मिल जाएगा यूरेका का।
volunteer बोलो।
It is volunteer and points out at page number 15
ये देखिए
or 15 or यूरेका का 15 of this affidavit
ये पढ़िए आप।
wherein the name of Eureka Stock and Share Broking Service Limited is appearing.
पेज नंबर 50
Full year page number 50 of this affidavit.
ठीक है।
Of the affidavit upon file.
Mr. Bengani kindly comes to question number 10 and 11 of your deposition dated September 29, 2023. And
When we go to the
kindly go through the affidavit of
10, 11 and 12 করে দিন।
kindly go through the affidavit of assets and tell as to whether you have mentioned in your affidavit of assets accommodation fees and is a limited accommodation. No, I have not mentioned anywhere in the affidavit of assets. I live in a since when you are residing in the self-same address, I reside in this address since 1978. Will you be in a position to disclose any agreement in between you and your landlord in respect of the said premises? I have an agreement with me. If the court ordered, I can produce it.
who are the other parties who had entered into an agreement, entered into such rental agreement? Who are the other parties apart from you? who
Other
had entered
party,
into such rental
मेरा दो भाई और है उसमें.
my two brothers are also residing there.
Not residing just now.
At present, they are not residing.
हाँ, लेकिन वो रेंट एग्रीमेंट में नाम है उनका.
Their names are appearing in the rent agreement.
Who are the two brothers?
नाम उसमें रेंट एग्रीमेंट में आप देख लीजिए. आप देख लीजिए ना.
आपको दो भाई का नाम पूछ रहा है.
हाँ तो
आपका ही आंसर देना पड़ेगा.
अच्छा सर, ये वीरेंद्र सिंह बेंगानी, सुशील कुमार बेंगानी.
सिंपल.
तो सर ये बिना मतलब का क्वेश्चन कर रहे हैं.
Legally entitled to ask you that question.
Okay sir.
So you are pursuing 17 proceedings, so you must have some knowledge about the court proceedings. Okay, next
question.
Finish.
Well, I'll finish for today, but Milad, I'll.
So then I have to give him 1 month's time, I think. Whether he will be here.
I am there, but
You're question me. I am asking you.
Yes.
Whether he will be.
No, he will leave tomorrow.
Tomorrow. Then
Tomorrow not possible, my lord. He is senior citizen, not well.
Yes.
If he at all necessary, he can.
You complete. Try to.
No, he has to give the accounts and all those things that he has.
Accounts, I will post it. If at all necessary, if I don't post
level নেমে যাচ্ছে সত্যি এখন
the accounts of for advocates fees.
Yes, he has to give how much he has expended.
Hampering on these.
I may render free services.
It will cause some problem to
has also rendered free services.
Okay. You complete
He
your
never
other
appeared.
parts. I'm leaving it to your discretion. Advocates fees, accounts, it will not help you in long run.
It will help me because Milad, the amount.
If you insist, I sell.
Because the amount involved in this proceeding will Milad show that Milad he is deliberately not making payment of that amount.
No, you have. I think you have got some clues.
Yes,
So then, carry on, please complete.
because he has,
I was paying to the all councils. He was just handing over money whenever it was available with.
Okay.
That is the fact.
Okay.
All fees were paid to the councils through my check or sometime in.
Okay, please carry on your other portion.
how this will be recorded, I don't know, that he is taking the responsibility. So if you are not getting it recorded, then please allow me to carry
No,
on.
it has to be recorded.
Please.
All fees are paid by the advocate on record.
No, I am not giving any opportunity to say anything in presence of witness. I have to ask him to go there, then you have to speak. You know, you are senior lawyer.
No, I am not senior, my lord.
Why not? You are not senior counsel.
No, my
Why?
lord. I am just helping my brother.
No,
Say
you are
some
senior counsel. Okay, I am not. Please.
Now, what is happening, my lord, because of this, he is getting the clue to give answer.
Okay.
He's standing every
He does
time
not
and
know the
saying,
English. He does not know the English.
yes, he doesn't know English. He's a stockbroker, he doesn't know English.
Okay. Come.
थोड़ा पानी मिलेगा क्या? पानी मिलेगा?
Never.
My lord, then my lord, allow him to come back whenever my lord pleases. He has to give those accounts. And then, my lord, on that day, I'll conclude formally.
Okay. How much time it will? 15 days?
For what?
He will, he is seeking for accommodation.
No, I am not. He has to. He has said that he will give.
No, whatever accounts is to be given, it will be typed and given to you.
No,
It will be typed and given.
This is not
আপনি
the
বলছেন
process.
যে আপনি চুরি করছেন, এটা কোর্টে দাঁড়িয়ে
Why you are arguing? Why you are arguing?
saying in presence of everybody that it will be typed and given.
It will,
And these are being live streamed now. Please understand.
This is a process. He has to come over here and to depose. Okay. So when 15 days will be sufficient?
My lord, it is not possible. He is coming from Delhi, not well, senior citizen.
Okay.
And he is just simply buying time unnecessarily. How many times? Not only
if
my lord has also interpreted.
So for one day I found that for your you have missed some brief or something like that.
Yes,
one day was
he has not filed affidavit. Last day he had not filed affidavit. The adjournment was taken by him.
What affidavit?
Hey, come. Hey, Asun. The learned counsel for the learned counsel. The examination of judgment debtor is resumed, but does not but is not concluded. Stop. This is the matter after 4 weeks for further examination of the judgment debtor. And এক মাস পরে ডেট দিয়ে দিন তো।
4 weeks.
My lord, will fix a time for all.
Yes, 12-15. 12-15.
Sorry, 3rd April.
3rd April দিও না।
3rd April.
নেক্সট তার পরের উইকটা দাও। 10th April করে দাও।
10th April.
12-15. Okay. Sufficient time.
कब तक का टाइम दिए?
10th April, 12:15.
10th April.
12:15.
हाँ.
12:15. सर आई रिक्वेस्ट यू, आप इनको बोल दीजिए जितना पूछते हैं नेक्स्ट टाइम पूछते हैं, दोबारा नहीं बुलाए। मेरे खर्चा भी लगता है और बहुत परेशानी होती है, बीमार रहता हूँ मैं।
तो भाई दे देगा।
भाई क्या दे देगा? आप भी दे देगा। आपको तो मिल गया ना।
He shall conclude. Yes, bring all these documents with you. Okay, all documents.
And my lord, kindly pass an order that my lord he has deposed to bring.
No, I cannot give any direction. How
Other
can I?
unnecessary, my lord, then my lord, if he doesn't bring on the next day, then I'll. I should not be forced by him to conclude if he doesn't bring.
You have taken.
He has deposed.
Then
maybe a direction is necessary. Maybe a direction is necessary because Justice Bhattacharya has also directed, then he has disclosed all these documents. He was not disclosing. The document that he filed by way of an affidavit.
Of my own, unless
He
directed.
is saying that I will not disclose of my own unless directed. Very well. নিজে বলে নিজেই কবর
The,
করছে।
the judgment letter is directed to produce all the necessary documents as deposed by him.
बस
Okay.
My lord, क्या डॉक्यूमेंट देना है?
क्या क्या वो आप तो बोला है वो डिपोजिशन में जो बोला है आप देखेंगे।
तो अकाउंट्स इतना लाना संभव थोड़ा ही है।
Next,
obliged.
Release for the timing. Yes, sir.
New chamber application item number 40.
My lord, this is my application for restoration, my lord, of a non-contentious probate application, my lord. It was dismissed for default, my lord, on 6th December 2019, my lord. My lord, on making inquiries, the petitioner found out about the dismissal only in the first week of January, my lord. My lord, the reasons
January
are
what?
given.
January when?
January 2024, my lord.
Why? He is not.
My lord, he was aged, my lord. He did not make any inquiries on the beneficiaries making inquiries, my lord.
You are the previous lawyer, you?
No, my lord. On the beneficiary.
What is the, that is a, it has been section 5 or something like that?
My lord, no, section 5 has been filed.
30 days, then without section 5, how can it be allowed? I do not know. Come back with some proper instruction.
My lord, kindly.
1 week.
1 week, my lord. I will come back with a section 5. Grateful, my lord.
কৌশিক এটা নিয়ে রেখে দাও এক সপ্তাহ পর একটা ডেট দিয়ে দাও কি বলতে হবে নট টুডে বললে তো আবার এ হয়ে
না না নট টুডে হবে না 13 মার্চ
হ্যাঁ নিয়ে নাও তো
item number 15.
My lord, this matter I appear on behalf of the respondent.
Who is for the plaintiff or who is for the petitioner?
Petitioner
order হলো না তাই তো
not here, but the only problem is petition has been filed for revocation of grant of probate, my lord.
So you have filed.
Yes, my lord, that has been allowed.
That has been allowed.
Yes,
Revocation has been allowed.
No, revocation. The grant of probate has been allowed. My application for grant of probate has been allowed by this honorable court on 12th of October. Subsequent to which an application for revocation has been filed. Things are complete.
So
petitioner is not here. Unfortunately, the petitioner is not here, my lord. But the only problem is
not today. Then not today. It will help you.
My lord, the only problem that I am facing is that because of pendency of this application.
Certainly. So give some notice. Give some notice.
That case, your lordship will fix the matter any day, my lord, so that like can be heard out and disposed of.
The learned counsel for the petitioner in respect of the revocation of the probate is not present. Stop. The learned counsel for the opposite party has submitted that if the instant petition has not been disposed of, comma, his client is not getting, is not reaping the benefit of the order granting probate. How many persons are there in your probate matter? Who are the beneficiaries?
Two daughters.
Two daughters. ওখানে লিখে দাও বললাম last time last না ওখানে হবে না is not the benefit of order granting probate in their favor, in the favor of the beneficiaries are not being affected. লিখে দিন, তারপর আমি কারেকশন করে দেবো, ঠিক আছে? স্টপ. On previous occasion, it was fixed when?
On the last occasion, the matter was appearing before Justice Ordinance. They had taken a time on that occasion.
New determination or something like that. This the matter on Monday?
Monday, can it be peremptorily?
Yes. Please the matter. Please inform your brother.
I'll serve a notice, my lord, informing that the matter will be taken up on
Yes,
Monday.
11th
This the matter on 11th March. Para the learned counsel of the opposite party is to communicate this order to the learned counsel of the petitioner. Stop. ঠিক আছে? ওই লাইনটা আমরা ঠিক করে দেবো। 11th March না?
11th.
Okay. ওখানটা আমরা কি লিখেছি? His clients are not getting his clients are not getting the benefits of the order granting probate in their favor. হলো, ঠিক হলো তো? We can take it. ঠিক আছে? In their favor. যেটা এখন বললাম ওটা করে দিন। ওকে, তারপর একবার দেখবো, হয়তো কারেকশনের পর আপনাকে পাঠাবো। আচ্ছা, ওটা পেরেন্টারিলি বলা আছে কোথাও? পেরেন্টারিলি লিখে দিন, আজ লাস্ট চান্স করে দিন। লিস্ট দি ম্যাটার এত 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 ফর হিয়ারিং অ্যাজ এ লাস্ট চান্স। ওকে,
item number 16
আর কিছু নেই তো? হয়ে গেল?
না না আছে
ও এখানে এই আচ্ছা, ঠিক আছে।
Item number 16, I'm told by Mr. Shoshaji Sen is appearing in the matter. So he has prayed for a not this week.
Not this week করে দিন।
তাহলে not this week হলো ইয়ে 11 11 16টা
17, item number 17 is my application.
item number 17
It's my application for discharge of the caveat filed by a deceased caveator. The legal heir of the wife of the deceased caveator had filed an opposition to my application. I am out of time to file my reply. Directions were there to file it within 29 February. I'm out of time, but I'm seeking 7 days time to
You're
file.
appealing on behalf of who?
I am for the applicant, the executor.
Yeah, executor.
And there was a caveator who filed a caveat in the probate proceeding.
My husband was the caveator, my lord. The caveat is since died. Now, my lord,
Affidavit was filed.
no, my lord, the affidavit in
Wife
support of
hasn't
caveat
filed.
was not filed. The wife of the deceased.
What is the timeline to file?
That has expired.
That has expired. I've taken out an application for the purpose of extension of time. The application we couldn't file because my wakalatnama is also not on record. When my wakalatnama, your lordship, I'm praying for leave to file the wakalatnama. And my lord, also a leave I'll need as an endorsement of the master summons so that I can file it in support of the caveat filed by my husband.
Lordship, only thing is that before Lordship doesn't give leave, I'm only objecting to granting of this leave because my application for discharge of that very caveat on that ground, because the time limit of 10 days has expired in the month of April 2023.
Yes.
So that my application is pending and in that application it is being contested. So if my application succeeds, then this question would not arise. The
Yes.
caveat will be discharged. If I fail, naturally this application, the question will automatically come. So Lordship will grant them that leave on that day. Lordship fix a day of hearing for this application. after 7 days. On that day, I'll file my reply and we'll
So
get it heard.
this is the matter after 7 days.
Yes.
Well, only
On that day,
leave
can be
to
granted.
file the wakalatnama. I need that endorsement.
That Bhogalatnama,
That I have to.
Lordship, Wakalatnama,
lawyer,
their Wakalatnama is already there. That is why they
Because
have already appeared.
there's been a change of advocate on
Wakalatama
record.
must be there. It is a between
The
court,
court
and
and
the
the
landed
advocate.
counsel. You know. I shall revere your brother.
That the caveator is not no more there. So whether the caveator's wife's Wakalatnama,
Okay.
That is what
whether
I
He is
not an interested party,
taking
Lordship
the
knows.
cause of the. He is appearing behalf of any third party.
Yes.
So he is a lawyer. He has the right to represent him.
Provided,
Whether they are
provided they have a
allowed
locus
or
standi,
not,
provided
that
he
is
has a
different.
locus
That
standi,
will be adjudicated.
provided he has a locus standi. If he doesn't have a locus standi,
That-
then no Lordship will not entertain any lawyer who comes to court and says, I want to argue an object. That cannot be entertained, provided he has to show that this is my interest.
Yes.
So caveators, this is
The
caveator's
test
wife.
is caveatable
He has
interest.
shown sufficient interest that
Very well.
because he's the wife of the.
Deceased
yes.
husband. Who had filed the case.
Lordship grants them leave
I
to
am
file
just
Wakalatnama,
giving
yes.
him liberty to file the
Very well.
Wakalatnama. Okay. The learned counsel for the executor has sought for an accommodation. Stop. The learned counsel appearing for the wife of the
Deceased caveator.
caveator has sought
Piyush
for a
Keriwal.
leave, for filing Wakalatnama. Stop. Leave is granted.
Grateful.
Leaves the matter after 7 days. Okay.
7 days, we'll come back. Lordship fixes a date for hearing. On that day, we'll matter
একটা ডেট দিয়ে দিন তো
13th March.
GA number 1 of 2023 would be heard on that day. Subsequently, if we succeed, then
Please the matter for hearing of the GA number such and such লিখে দিন তো
she keeps it after 14th, any day after 14th March.
14th March.
Any day after 14th March.
Okay, no problem. 15th March.
15th March.
15th March.
15th March as for hearing.
Grateful.
Only leave for filing Wakalatnama, for raising bills.
No, no, today Wakalatnama, tomorrow that application will come. Yeah, it's for 1 year it is going on.
You are
So
preventing your brother.
I'm sure he will gain the fruits of it.
the question is not always about fruits of us. The fruits, actual fruits will not go to someone else. Grateful.
এই না পুরো আমার তো আমার আমার একদম গার্জেন ফাইল লিখতে হবে আনন্দ লোক নিয়ে পুরো একদম হ্যাঁ প্রত্যেকটা হবে হয়ে গেল তাহলে আর হবে না Yes. Oh, will you come back at 2? Okay. So not today then?
I was praying, but there are several applications on the list. There was a report filed by the learned registrar pursuant to an earlier order that these are their applications pending, these are not. I love that report is there, your lordship.
দেখো তো ওটা হবে না
I will try to assist your lordship's
Yes,
office.
sir, 49 করে 49.
I love
How only 49?
only 49.
Your other side?
They are not here. My lord, in fact, also one of the legatees, my lord, this is an application for grant of probate in which probate has been granted, but the administration is still with this honorable court. My lord, one of the legatees has expired.
49.
So we shall have to bring her death on record and bring her here in the records. My lord, if your lordship kindly keeps it after 2-3 weeks,
Okay. After 2-3 weeks take it. After 3 weeks take it.
lordship kindly
49 দিয়ে দাও
49
the learned counsel for the
let Mr. Deepak Kumar.
no you are appearing on behalf of
One of the legatees. Some of the legatees. Deepak Kumar Sarkar, which
the learned counsel for the legatees Deepak Kumar Sarkar
and
others has sought for an accommodation. Where is your other side?
they are all supporting.
Stop. Please the matter after 3 weeks.
27th March.
27 March.
But if your lordship so desires, your lordship can record that it is submitted by me. One of the legatees has expired.
Stop. The learned counsel has also submitted that one of the legal heirs, namely
Krishna Sarkar.
Krishna Sarkar. Sarkar has died in the meantime. Stop. So you have to take steps.
Any of the parties, I will advise my client to take steps. My lord, if your lordship so desires, your lordship can record that.
The learned counsel has also submitted that his client will take steps in accordance with law for bringing the legal heirs of the deceased Krishna Sarkar on record. That's all.
My lord, because probate has already been granted, my lord, will not, they are only there is no question of bringing on record. Only the date is to be recorded and notice to be given to the heir.
To take appropriate steps to take appropriate steps. Bring on record by heirs pairs কিছু বলতে হবে. The Learned Counsel for the has take appropriate steps.
I'm grateful, my lord. I'm deeply honored.
That's all. হয়ে গেল 49. Anything else?
No.
Okay. এটা appropriate step.